Hello and welcome to my digital property presentation. My name is Colby Gibson. I'm going to be taking you through this. Let's go ahead and get started. So what is digital property? Digital property is defined as valuable, virtual, or digital assets in cyberspace. Digital property is content that is owned by an individual that is stored in digital form. Digital property is intangible personal property, and the content can either be stored on a device owned by the individual or devices accessed via the internet. Examples of this are data, online accounts, software, photos, videos, and text files. There are ongoing complications going on in the world, and particularly on the law side of things when it comes to digital property. Let's look at a few of them. Digital property ownership. Who owns and has the rights to digital property? The majority of people would claim that whoever created the digital property would be the owner. Well, this is mostly true, but ownership is constantly being challenged by the nature of digital technology. Ownership questions relating to data and databases are numerous in current legal and ethical debate. An example of this is asking, posting a photo on Facebook, now, is it really yours? Our next issue is, should we protect digital property? I say yes, but there's an ongoing argument between protecting it and not protecting it through laws. The federal government and proponents of protecting digital property believe that protecting digital property through law is the only way to encourage creativity and getting people to continue to create digital property. Proponents of not protecting digital property through law believe that digital property should be protected through self-regulation. And our third issue is how we can protect digital property. The basic methods to protect digital property are through patents, copyrights, trademarks, and licensing. We will talk about these more in just a second. Let's look how we can protect digital property. The first way is through a patent. The U.S. Patent Office grants these to the inventor and is usually good for about 20 years. In the digital and computing world, it's still a developing field. Patents exclude others from making, using, or selling the invention in the U.S. A while back, Amazon.com created its one-click buying technology and incorporated it in its website. Later, Barnes & Noble infringed upon their patent by creating Express Lane. In Amazon.com versus BarnesandNoble.com, Amazon relied upon a patent to allege that it alone had the ability to use one-click ordering routines. The matter was settled in 2002 without final judicial resolution, and the settlement details still have not been disclosed. Today, one-click buying technology is common practice on the internet. This goes to show that even though there are patents on digital technology, the fast-moving atmosphere of the digital world makes it difficult to protect every aspect. Next, we will look at copyrights. Copyrights have been the primary means of protecting most expression on the internet. A copyright protects the rights to publish, duplicate, or alter expressions of ideas. In 1997, President Clinton signed into law the No Electronic Theft Act. The NET Act confers copyright protection for computer content and imposes sanctions when infringement is committed for commercial or private financial gain or by reproduction or distribution. In the year 2000, the Recording Industry Association filed a lawsuit against Napster for copyright infringement violations. Napster had a file-sharing service where users could swap music files without having to pay for them. Napster was found guilty of illegally distribution of copyrighted material because the musical artists and the recording companies held the copyrights to the music. Next, we will look at trademarks. Under the Lanham Act, trademarks prevent others from using the same name, word, or symbol. A trademark helps distinguish goods from others. A trademark infringement can occur when another company uses a company trademark to enhance its own image. This includes using or selling domain names that resemble or duplicate the names of existing corporations or entities. This is otherwise known as cybersquatting. In 2006, Google found itself in a lawsuit against a computer repair company named RescueCom. This occurred after Google sold the company name RescueCom as a keyword term to RescueCom's competitors. Google ended up winning because the court determined that Google's use of the word RescueCom did not constitute a use under the Lanham Act. And now finally, we'll look at licensing. Licensing is a contractual agreement made between a consumer and a software vendor. This allows the buyer to use the product but restricts against duplication or distribution. Legal trends seem to favor enforcement of software licenses, and courts have upheld the limitation on the vendor's liability for errors within the software program. When Facebook took it upon itself to incorporate the Yahoo News web application into the Facebook mobile interface, Yahoo filed suit against Facebook for neglecting to purchase licensing rights to the Yahoo News web application. Next, we'll look at a very interesting topic that has come up, which is what happens to your digital property after you pass away. This is a more recent issue that past generations have not had to deal with. This next video introduces some of the issues that have arisen.
The topic most people don't want to talk about has gotten even more complicated thanks to the digital world. What will happen to your stuff when that time comes?
In the world of estates law, when somebody dies, they have a house, they've got bank accounts, they've got life insurance policies. Now they've got digital assets.
Digital property includes everything from pictures on Facebook to an iTunes library to ebooks, even online bank accounts. It all needs to be looked after.
Just because you pay for something doesn't mean necessarily that you own it.
Almost every digital site and property has a different rule. The topic has yet to be broached in court, so there isn't even any precedent to refer to.
Having looked at some of the terms of use, I think there definitely could be a battle about what's personal. What does transfer mean?
Take Facebook, for instance. What we know for sure, once you upload photos, you don't necessarily own them anymore. You can't even contact Facebook to have a page shut down when someone dies.
It's actually in a state of flux in terms of how they deal with access to the Facebook account.
Then there's iTunes. Your playlist might be very personal, but it's not yours to transfer, no matter how your will is written. Ultimately, your iTunes library dies when the owner does. Same goes for ebooks. An extensive book library is not like the one your grandfather had, but if you have the computer it's on, then you may have access.
And a lot of this is about access. If you have the access, even if you don't exactly have the right under the terms of use, then you probably have what you need.
As for your banking information, passwords and account numbers should be passed on. Will makers have a section specifically for that information. That said, a lot of rules get thrown out when borders are crossed. Since the web is worldwide, there are a lot of very gray areas. Laura Zilke, Global News.
A lot of people keep usernames, passwords, and other important information for accounts and other digital property locked up somewhere, or just in their heads. The main idea is that you need a plan before a person passes away. This can be done through digital property management and/or digital estate planning. Both of these things that I just mentioned have come up recently and offer solutions to maintaining digital property as well as ensuring that the proper procedures are carried out once the person passes away. There is personal property that cannot just be deleted, such as a Facebook account. Because of this fact, somebody, whether it's a professional, a family member, or a trusted individual, needs to have the required information to access their personal property. In conclusion, digital property is very broad. It is basically any information that is in the digital world. The rules as to who owns the property and what you can do with it are not clearly defined. The internet and the digital world have moved so rapidly, and will continue to do so, and makes enforcement of digital property rights difficult to enforce. There are ways to protect your digital property, but even then, nothing is a sure thing. Here is a list of resources that I used to create this presentation, and thank you for listening.